ensures your property is distributed according to your wishes. Durable power of attorney. This person will act on your behalf when you are unable to do so. Beneficiary designation. You want to decide your beneficiaries. If you don't, a judge might make that choice for you. Letter of intent. It's a document left to your executor or a beneficiary, and it defines what you want done with a particular asset after your death or incapacitation. Healthcare power of attorney. This will designate another individual to make important healthcare decisions on your behalf. Guardianship designations. If you have small children, you want to make sure you decide who will care for them if you no longer can. For more financial information, go to aarp.org/money.
Hello, my name is Sonia Gibbons-Reed, State and Community Engagement Analyst for AARP Illinois. AARP is a nonprofit and nonpartisan membership organization that's been working to promote the health and well-being of older Americans for more than 60 years. Today's virtual event is the second in a series of virtual offerings that is taking a deeper dive into elder law. Many of our key questions being answered by our elder law attorney are ones submitted by you, the viewer, and we thank you. By connecting you to resources on advanced planning that can eliminate problems before they arise and empower you with the information to plan. Today, we are honored to have David Lanier, an AARP Illinois volunteer, joining us. Welcome, David.
Hi, my name is David Lanier, and today I want to welcome you to a virtual event for AARP. AARP is a nonprofit, nonpartisan organization which is comprised of members in the 50-plus range. We currently have over 1.7 million members in the state of Illinois alone.
Thank you, David. Today, we will be continuing our conversation with Steve Anderson. Steve is a partner in the government consulting practice Necritz Amdor Anderson Group, providing counsel and guidance to entities seeking to advocate in the Illinois state capitol. Prior to joining Necritz Amdor Anderson, he was a commissioner of human rights for the state of Illinois, appointed by Illinois Governor J.B. Pritzker. Steve is a retired member of the Illinois House of Representatives. He has also been a practicing lawyer since 1992 with a focus on elder and municipal law. He is licensed to practice in Illinois, the Seventh Circuit, and the United States Supreme Court. AARP Illinois welcomes back Steve to today's conversation on elder law and estate planning. I am confident. Oh, go ahead, Steve.
I'm sorry. Good morning, everyone. It's a pleasure to be back. This is version 2 or episode 2 of our elder law estate planning conversation. We had a great conversation the first time. Just a couple of things I wanted to say at the outset. Number one, I want you to leave here. I want you to come into this, and I want you to leave here with one important concept. Don't worry. Okay? A lot of people spend a lot of time worrying that they're going to have a problem with their estate plan or a problem, with how they plan or how their assets get distributed. The job here today is to try to explain those concepts so that you can follow up and get, good advice and make sure things can be as good as they can be. But let's say that doesn't happen. It's okay. Many of the laws in most of the states are designed for when people don't plan. So I don't want you leaving here thinking if I don't do everything perfect, it's a disaster. It won't be. We're going to go through these topics. We're going to talk about best practices, but at the end of the day, you're going to be okay. I want you to understand that. I don't want you to stress over whether you get everything done, because to be honest, most people don't get everything done, and that's okay. So number one rule for today is don't worry. Number two is I think it's always important for you to recognize, and the video hinted at it, the opening video, is communicate with your loved ones. Communicate with the people that you want involved in what happens to you, maybe when you're incapacitated and can't make decisions anymore, and maybe when you pass on, what happens to your assets, what your wishes were. Because as good as we can be as attorneys drafting documents, it will never be successful if you don't have those good conversations with your loved ones. So those can be great conversations, by the way. A lot of people are very nervous about it, think it's an uncomfortable subject, but a lot of times it can be a very beautiful moment between family members or whomever you care about that you would be talking about. But success requires that you have those conversations. And last item for the introduction is, since this is going out to people beyond just the state of Illinois, I'm going to answer these questions as what you might call generic US law, as opposed to Illinois specific or any other state specific. Most states are pretty similar, but there are differences. So at the end of the day, no matter what I tell you, when it comes to your particular estate planning documents, your particular plan, please check with an attorney who's licensed in your jurisdiction, in your state, wherever that might be. And with that, I'm ready to take some questions, Sonia.
Okay. I am confident our 30-minute session with today's guest will be insightful. And if you would like to stay on top of the most recent and up-to-date information after this event, you can visit states.aarp.org/Illinois. And so with that, let's get started. Here's the first question, Steve. Could you explain what power of executor of the will is versus trust?
Sure. So this question comes up a lot. What's an executor? What's a will? What's a trust? A will is a document that has very specific formats for how you do it, how it's witnessed, and ultimately it can be filed in a court and it can be part of a probate estate. What it does is it tells whomever, whether it's a judge or just the people that you love, where you want your assets to go after death. A trust does the same thing, but it does it outside of probate. So there's no court process involved if you create a trust. There are options. Neither one is required, and you can pick between them, and we can talk about the advantages and disadvantages between them. So what's the executor? The executor is the person you put in charge in a will. Okay, so an executor connects with a will, and then a trust doesn't have an executor. A trust has a trustee, largely performs the same roles, little different. Trusts are more independent. Wills are governed by the court system. So they do very, very similar things, but they do them in two different ways. So hopefully that makes sense.
Okay, let's take a viewer's question. Our first Facebook question is, what is the difference between a will and trust? Well, I think you just explained that a little bit. Another question, how do I keep my condo from going into probate?
Okay, let me follow up a little bit on the question of the difference between the will and the trust. So I've already described what they are, but what I didn't say was, why would you pick one over the other? And typically, the answer is that people want to avoid going through probate. Probate is the court-appointed process where your assets are distributed. It costs money and it takes time, typically a minimum of 7 or 8 months to go through that process, and it could be more. So a lot of people like to avoid that. The way to avoid that is using a trust. So all your assets are placed into trust before your death. So technically, they all get taken out of your name and put into the name of your trust, which you control until you can't. So it operates differently. And a lot of people don't want the public disclosure, if you will, that probate process causes. So that's one of the reasons. Some people like to believe it saves money. Sometimes it does, sometimes it doesn't, just depending on the size of your overall estate. The bigger your estate is, the more likely a trust will save you money. The smaller it is, less likely. So that's that part. Now, how do I keep my condo from going into probate? There's a couple of different ways. One, I just told you about. You could put your condo into trust. And by doing that, when you pass away, that condo will go by operation of the trust, which means it doesn't have to go through the probate process. There's actually another way, at least in Illinois, again, this is maybe Illinois specific, where you can use a title company. If that's like probably your largest and maybe only asset of significance, that asset, a title company will oftentimes what they call insure over or protect the title to pass it to whomever you had intended without going through the probate process. So that's an option, but it may not be an option in every state. But for sure, a way of avoiding it is using a trust.
Okay. Thank you to all of our audience members for joining us today. And our next question is a YouTube question. Can you explain the Illinois estate tax rules?
So Illinois, how shall I explain this without saying too much about the federal law? So we all operate under a dual system. There's federal estate tax rules, and then there's Illinois estate tax rules. They operate in conjunction. Largely, your choices, the ideas that you're concerned about. In other words, usually the concern is avoiding taxes, as we all would like to do. When you do that, it's primarily done at the federal level, and then the state level sort of follows naturally with that. There are generally not too many estate tax implications, either at the state level or the federal level, until you get to substantial numbers of assets. So we're talking over $1 million or $2 million, especially if you're married, because there are exemptions, complete exemptions for transfers between spouses. There would be no tax implications there. And only if you're above that level do any of the tax rates kick in. So for the most part, most people will not have a problem with that, where they won't end up having to pay anything. The only thing you will have to pay is any income that's generated off of the assets after you pass away. I shouldn't say you, I should say your heirs will have to pay. But again, typically that's pretty minimal. And then those assets will be transferred. You'll file oftentimes just one estate tax return. It's called the first and final. And by doing that, you end any interaction with the IRS and the Illinois Department of Revenue.
Okay, another Facebook question. What is the cost of having a will or trust prepared?
That's a great question. And it's really a follow-up on what I was talking about before on this debate between a will and a trust. So the way that I like to explain this is it's more a question of when you want to pay rather than what you want to pay. The expenses can be very similar. And I'm talking about a person with an average, level of estate. They have 401ks, savings, they have a house or a condo, a car, and some amount of assets, but not like crazy wealthy. Let's just be clear. I'm not talking about that. So in doing that, when you ask what's the cost, so the cost of the will is very inexpensive. You can probably get it done locally for a few $100s. So not very much at all, maybe $1,000 depending. But for the most part, it won't be that expensive. A trust will be much more expensive. So a trust might be $5,000 or $10,000 because there's a lot more involved in setting it up and making sure it works right away. A will just sort of sits there. The trust becomes an active legal document the moment you sign it. So it's much more expensive at the outset. But, and this is the big but on this. So you paid less to get the will, but then upon your death, the will has to be probated. And probate means you have to hire an attorney, typically, and you have to go through a court process, which has filing fees, publication requirements, a lot of different steps. And so there, the money might mount. So it becomes a question of, do you want to pay a little now and then maybe more later? If you like that answer, then you would do the will. And if you would prefer to pay more now and avoid probate and pay less later, but also avoid public disclosures, and there are other advantages, then you might do the trust instead. So I'm not going to tell you which is right, just telling you that's the implications.
Okay. Another viewer's question. We have a savings account from a relative who has passed away. We have asked the bank who the beneficiary is on the account, and they won't tell us. How can we find out who the beneficiary is so that we can notify them?
So I know how frustrating that is, and the bank is doing the right thing because until you present them with some legal authority to know, they are protecting that person's privacy. So as frustrating as it is, they're doing the right thing. They're doing what I would hope they would do for me, is to make sure that my privacy is protected. So there's two options, and one is for sure, and the other is only a maybe. So the maybe is, if you have power of attorney for property, you can present that, and then in all likelihood, they will tell you the details, of the account. But banks right now are not required to honor the power of attorney. That's something that's actually very controversial, and some legislatures are trying to change that to make it mandatory. But right now, it's optional on their part. A lot of people think they must disclose, but the truth is they don't have to. So that's why I call that a maybe. I also hope that will change in the future, because the other option is probate. Even if you don't have a will, let's say that relative didn't have a will, didn't have any documents, you can still go to probate, file a claim, and say, we believe that there are assets out there and we need to gather them. We need to find out, who's there, whether or not there's a beneficiary on that individual account, that sort of a thing. And a court will grant you that power, and then you'll have a document. You'll have the ability, they're called letters of office testamentary, to be able to go to the bank and present, and then the bank has to tell you. So there is a way, but I'm not telling you that it's necessarily all that easy, unfortunately.
Of course not. Okay, another YouTube question. If your spouse has an illness that affects their cognitive ability, what is the best way to set up your estate to prevent them from spending impulsively but still supporting them?
Sure. And this is an unfortunately common situation for people of all ages, but it certainly happens a lot more as we age as well. So a couple of things that you can do is, one, I would alert your banks, the places where you keep your money, to the circumstances, and they will make recommendations to you. Probably the biggest recommendation will be to take your spouse's signing authority off of those accounts, so they can't write checks, and take away the credit card, so they can't spend your money in that way. The other thing that you can do is you can, on your power of attorney, remember we're talking about your power of attorney, not theirs, since you're looking to protect your money from them accidentally or unintentionally spending it because of their impaired cognitive ability. When you do that, don't list them. I mean, it's a normal and natural thing to say, I want my spouse to be my power of attorney. But if they don't have the ability, the mental ability to do it, don't list them. List somebody else. So that if you've taken these steps, if you've gone ahead and removed them from signing authority, and you've taken the credit card away so they can't do those things, then make sure if you become impaired, right, you haven't accidentally given the power to your spouse who's already impaired. Give it to somebody else, a son, a daughter, a trusted friend, who can also then protect both of you at that point, when that time comes, if it comes.
Okay. What would happen if I or a family member did no advance planning? Would we be at risk of losing everything or paying higher taxes?
So excellent question. And this is what I started with. Remember my first rule of the day, don't worry. So the answer is no. If you did nothing, would there be maybe some more difficulties for your family members in getting things processed? Yeah, probably. It would be a little harder for them than if you had documents in place. But most state laws are designed to give assets where you would probably intend them to. So when the opening video said, if you don't designate beneficiaries, maybe a judge will decide where it's go. That is true. But the good news is it's not like the judge can just willy-nilly decide who your estate assets are going to go to. Instead, there's a set kind of a default rule of where your assets go. And not surprisingly, it follows bloodlines. So that if you have children, let's say you have 3 children, the default rule will probably be an equal division between the 3 children. If you have 1, it's going to be 1. If you have 1 child, maybe another child who's passed away, and a grandchild, the grandchild's going to get half, and the living child is going to get the other half. And let's say you have no descendants, then it's going to go up the bloodline. It will probably go to your mother or father, and presuming they're no longer with us, then it would devolve down to brothers and sisters. So let's say this, if you fall into the category of people who generally want their assets to go to their children, you don't have to worry. If you don't want your assets to go to somebody who naturally, would normally be in that line, then it's more important to have those documents. But to answer the question, am I going to pay more taxes and am I going to lose everything, or is the family going to lose everything? Absolutely not. You are not. So
good to
don't
know.
worry.
Okay. A new YouTube question is, if I go the trust route, do I have to inform my bank or financial advisor in order for them to update their records?
Yes, 100%. Because remember, with a trust, the trust is alive and active the moment you sign it. So one of the biggest mistakes that happens in trust creation is you'll go to the attorney will draft the documents perfectly. Everything will get done. You'll leave that office and you'll think you're done. But the answer is you're not done. You're not done until you do exactly what the questioner asked. You have to update and you have to change title on your document or on your assets. So your bank, let's say your bank is currently, your account is in your own name. My name's Steve Anderson, so my account name would be in my name. If I create a trust, now it's going to have to change. The ownership literally changes to the trust of Steve Anderson. I'm no longer the owner. I still control it. Don't worry about that. I still have absolute control over my own assets, but it's not technically in my name anymore. So you have to do that with everything, and that includes real estate. So with your home, you have to get a new title, which is not as hard as it sounds. The attorney can usually help you with it, the attorney who draft the trust. And by doing so, you're actually, again, changing that title. So if you don't do those things, then the trust you just spent a whole bunch of money on will effectively be worthless, and you'll have to go through the probate process. So it is absolutely critical that you do that.
Okay, we have a new Facebook question. Can my will allow the executor to access my bank account in the event I can't pay my bills?
So let's be very careful about that. So the executor, their job kicks in when you die, okay? Because the executor is the person who is administrating the probate estate. So the precise answer to the question asked is no. However, there is ways to do what you want, which is you want to have people to have access to be able to use your funds for your benefit. One is the power of attorney for property. You saw that in the opening video as well, is that designates somebody when you're incapacitated to go ahead and be authorized to make those sorts of changes, whatever they need to be. Always in your interest, though. The law requires that. So it's never about, the person who you name, they can't take the money and, go to Florida or something with it for their own benefit. So that's the primary way of doing that. The other is the trust. Remember, if you go the trust route, what that means is that you're the initial trustee of your own trust. But if the attorney has prepared the document correctly, which I'm sure that they will, there will be successors. So it will say, if I become incapacitated, then so-and-so is now the trustee. And so then they can take care of working with your banks and financial institutions on your behalf.
Okay. And in a new YouTube question is, should I have a joint trust or a separate trust with my spouse?
That's a good question. Generally, we do separate trusts. That's not an absolute though, and that's one where I think that it's best that I don't give you a great answer for that, because that could be very state specific, where there might be either tax advantages or legal issues that I'm not aware of in a different state. But generally, at least here in Illinois, we would typically have two trusts: one for you, one for your spouse.
Okay. What happens if you are an only child, single, and have no children?
What happens with your estate, I'm assuming the question is. So, like I said, with most state laws, there's sort of a default of what happens to your assets in that circumstance. In that one, again, they're going to go up the chain. They're going to go up your family chain, and somewhere, presumably, there is somebody. So it could be like a second cousin once removed, if you truly, don't have a lot of family either left, which is not that uncommon, or you just don't have, there never was a lot of family. But there is usually someone somewhere. Now, that may not be who you want your assets to go to. So if you're in that situation, strongly recommend, again, don't worry, but strongly recommend that you, at a minimum, create or draft a will for yourself saying, I want it to go to my best friend, Joe, because Joe won't be in that line. Your friends won't be in that descendancy line. So if you want it to go to somebody who's, your beloved friend, totally fine, but you have to then say it. You have to say it in the document.
Okay. Probably have time for one more question.
Okay.
This is a YouTube question. Does the trust have to pay taxes annually, and who runs the trust?
Right. So the trust will typically, during your lifetime, will not pay taxes. It's a pass-through entity. So what that means is that you'll still end up paying taxes. There's no difference. There's no effective difference. But upon your death, yes, the trust will have to pay annual taxes for as long as the trust exists. So just like, because it lives beyond you, that same entity, the trust, because it lives beyond you, it really will have to do that. Now, many trusts will terminate shortly after your death, because their job then is only to avoid probate and then distribute your assets. So once they've distributed the assets, the trustee then can close the trust, and then they won't pay any more taxes.
Okay. There's been so much great information, Steve. Thank you so much. And I'm sorry to say we're near the end of our time for this live conversation. Do you have any final comments before we close?
Well, number one, I want to say thank you. The questions are awesome. I really enjoy that we get live questions and that they're real, not just staged questions, because that makes this a lot more interesting. It's my hope that I've conveyed some valuable information to you. Like I said, it's important that if you follow up on any of this, that you do so in your own state with a competent attorney. And there are plenty of them out there, and so I encourage you to do that. But never forget my first rule: don't worry, it's going to be okay. Even if you don't get to it all, it's going to be okay. And I do want to thank AARP for letting me spend this time with you all.
Thank you so much to our special guest, Steve Anderson, for joining us today. It's been a great conversation. And thank you, AARP members, volunteers, and listeners for joining in this discussion. Continue to join for our virtual events with AARP Illinois. And if you're looking for more information from AARP, please Google our website at AARP Illinois or at states.aarp.org/Illinois. Thank you and have a wonderful day. This concludes our virtual event.